If you're just joining us, we have Stacy Takekawa, an attorney, estate planning attorney with the Estate Planning Group. And in the first segment, we talked about a little bit about what probate is and why it's important to have an estate plan to avoid going through probate, because it could be a long and tedious process. And so wanted to continue our conversation about, we just touched upon why some people may want to go with a will versus a trust, mainly for finance purposes, because it's a lot cheaper to go with a will. But if they went with a trust, I mean, I'm sure there's different types of trusts. Can you kind of briefly go over what those are?
Yeah, so there are different, first of all, there are different types of trusts. The one that when people think of estate planning for basic purposes, it is a revocable living trust. But your revocable living trust can be structured in lots of different ways. And at our firm, there is sort of a sliding scale for price purposes for if you have a very simple plan versus if you have a very complicated plan. So as far as revocable living trusts go, that's the main tool that we're talking about for estate planning for avoiding probate. There are irrevocable trusts. Those are things that are used by folks who are maybe doing Medicaid planning or who have high net worth and are trying to reduce their estate tax, try to reduce their estate so that they pay less in taxes upon passing. But for most people, we're dealing with revocable living trusts, but like you said, those can be structured differently and adjusted to fit the person's situation, their family, but maybe also their financial restrictions at this point.
Mm-hmm, mm-hmm. And when you say revocable trust, that means that they can change it at any point in time.
Yeah, so the revocable living trust can be changed at any time, so long as the person still has capacity to make those changes. And so yeah, like I've got a revocable living trust that I'm sure will be changed many times in the future, given if I get married, if I have children, that sort of thing. So folks can set up, if you've got a revocable living trust that you set up in the 80s, we can still use that same trust. We just revise it and change it and update it.
Okay. And it's what you mentioned an instance where one may have an irrevocable trust, whether it's for Medicaid purposes. What would be a benefit to that? I mean, why would one want to do that versus the revocable?
Yeah, so the irrevocable trusts are used, like I said, for in Medicaid planning. You can what's typically happening, and of course, if you're trying to do this, you need to use an attorney who specializes in this area, because the laws governing Medicaid are very specific about these types of trusts and these transactions. But essentially, an irrevocable trust takes something that you own, you put it into a trust that says who's going to get it, who's going to be in charge. But other than that, once you put it on paper and sign it, you cut off all strings to it. You no longer have control. You're not the beneficiary. I shouldn't say all strings. There are some things you can control, like who's in charge. But in order for it to qualify you for Medicaid, in order for it to work to get the other reason I mentioned, where people are trying to get assets out of their estate, they're trying to basically give their stuff away so that they technically have less. But once you do that, it's gone. You can't change your mind later and say, oh, never mind, I don't need Medicaid, so I want my house back, or I want my investment property back, or that $100,000 I put in that trust, I want it back. You typically cannot do that. So irrevocable trusts are tricky, and they shouldn't be entered into lightly.
So you better be sure that's what you want.
Exactly.
Okay, so aside from the two, are there any other types of trusts, like a living trust?
So the revocable living trust is that there are different types of trusts for different types of planning. For example, if you had charitable intentions with your assets, like if you want to leave your house to a charity, but in the meantime you live there, or maybe it's the investment property and still want to get equivalent of the rental income from that property. There are charitable remainder trust or charitable lead trust, but those are all very specific. Like I said, the main trust that most people have and most people think about is the revocable living trust. That can be structured in a lot of different ways, but I mean, there are tons of different kinds of trusts that achieve different kinds of tax planning, goals, or the charitable, if you have charitable intentions for your assets, there's different types of trusts you can set up for those situations.
Mm-hmm, mm-hmm. And so, having a trust, of course, you are the trust would be under your name. You would have a trustee and then a beneficiary. Typically, your beneficiary would probably be your kids, or whoever you want to designate, but most of the times it would be the kids, right?
Mm-hmm, yeah.
And at what point do, say, the kids take over? Like at a certain point, you're not going to be at capacity,
Mm-hmm.
right? And so, at what point do the kids then, take over and say, hey, this is what we want?
That's a great question, and it's something when, going back to when you're talking about whether someone would just want a will or a trust, trusts can be very specific about who gets to decide when, let's say, mom or dad has become incapacitated. And your trust can lay that out to say, okay, it's only when my primary care doctor, whoever I've established as my primary care doctor, says that, in their opinion, I no longer have capacity to do this. Or it can be, I don't want to have to be dragged in front of a doctor. I want it to be a majority of my kids. Or I just want my spouse to be the person to make that decision. And if my spouse isn't around, then I want it to be a majority of the kids. I mean, you can be very specific about, as far as the trust goes and when the kids or the next trustee would take over your trust, you can be very specific about who makes that decision. Because otherwise, if you just have a will, again, wills don't work, they're not valid until you've passed away.
Mm-hmm.
So the incapacity part of it can get tricky for folks who don't have something else in place for, that period of time where they may become incapacitated before passing away. So if there isn't something in the trust that addresses that, then typically a doctor's note that says, and sometimes there are specialists, geriatricians or neurologists who will make that determination, but that's up to the doctors.
Okay, so backing up a little bit, so you said a will is only active after a person has passed.
Yeah, and after it goes through probate. So sometimes when folks just have wills, if you have a power of attorney, which is another document that would be part of an estate plan, that can take over when you're incapacitated, though again, you may still have to have a doctor evaluate you, or you may, as the kids, have to go take your parents in front of a doctor or a geriatrician or specialist to say, oh yeah, they aren't able to make financial decisions anymore. The power of attorney will allow you access to financial information, bank accounts, Social Security, dealing with Medicaid or any of those things. But once you pass away, the power of attorney stops working. It's no longer valid. So then there's this sort of gap period between the time you pass away and the time your will goes through probate, where nobody can do anything. So that's where, it can take sometimes, banks are just frozen for 3 or 4 months before you even get before the judge. And then if there's any problems, like I said, with the one you were talking about where it took a year, that's not uncommon. And, folks are sometimes worried about, well, how do we pay for the funeral? What do we do with the final bills? There's a bank account sitting there with enough money to handle it, but no one has access.
Right.
So again, which is why I said when most people come in and we explain all of this to them, they end up going with the trust, because the trust is effective as soon as you sign it. It keeps going, it gets to you get to say in there, when are you no longer in charge and who's in charge if you can't do it. And then it will keep going, and it's a pretty smooth transition between the incapacity and passing away, because you don't have to go through a court process. You do have to sign some paperwork, but that's it.
So that's why a trust is a better vehicle than a will. I'm curious to know, like, during that gap period you said of the time of passing to when the judge says, okay.
Mm-hmm.
Is there, I guess the beneficiaries or whoever's gonna handle the estate after the passing, if there's a will, don't they need an attorney to help with that part too, with going the probate process?
I would say yes, but technically no. Everyone has equal access to the judicial system. You can try to navigate it on your own. I've
Right.
had a lot of folks who Google things, and download things, but it's going to be a lot quicker and a lot easier to navigate if you use an attorney. I know for some things in family court, the court website or the court itself can give you forms to fill out, right? That you just go in, this is my issue, okay, fill out this form, and it's a little easier for folks to navigate on their own. But for the First Circuit Court, the probate court, where this type of stuff happens, the court can't help you, they cannot give you legal advice, and it can take, if someone were trying to do it on their own, I'd say it would take at least 3 times as long. Just because you don't know where to start,
Right.
reading laws and court rules is gibberish for a lot of folks, so, yeah.
So I guess in the end, you're pretty much, it's not a financial advantage to go with the will, because if you end up having to hire an attorney to help you with the probate process, it probably would add up to creating a trust to begin with, right?
Yeah, it's just the folks who, it's funny to me, it's just when the clients will say, well, if they want the house, they'll have to pay for it, kind of a thing. So, yeah, it does sort of wash out in the end, as far as whether you pay for it after you're gone or you pay for it up front. But I just think the priceless sort of things, that the peace of mind, the
Yes.
quickness, just making it easier for everyone.
Yes.
Those are the sort of things that a trust will give you, and so the peace of mind really, I think, is worth it for folks.
Mm-hmm. Yeah, I have to say, I mean, on a personal note, when my grandma passed away, I mean, even though she didn't have a trust, but she didn't have a whole lot of assets anyway as well. So she just getting her monies out of her bank account, that those kind of things. It took some time. It was a little challenging.
No.
Yeah. So I mean, from my personal experience, I mean, my parents didn't know what to do and how to proceed, and so I learning from that experience. Of course, shortly afterward I talked to my parents. I said, you folks should set up a trust too, because they have a house, right? So that's something that's going to be a big thing for us to take care of after they're gone. So so they haven't taken action yet, but I'm still pushing away at it. So hopefully they'll be ready for that step soon.
Yeah, and I would say most of our clients come in and they've had some experience with some loved one passing away, aunties, uncles, parents, grandparents, and they see how complicated it is, even if it isn't that much. It's just a little bank account here, maybe they have stocks from back when they worked at a company, and then the house shouldn't be too complicated, and it shouldn't be, but it can get there just depending on how many siblings are involved, how many debtors might be involved, or creditors might be involved. So it just can get out of hand very quickly, whereas an estate plan really isn't as daunting, I think, as a lot of folks think it is, right? When I sometimes sit down and explain what all goes into the plan and what decisions they need to make, sometimes I have folks at the end saying, is that it?
Yeah.
Are we done?
Yeah.
That's it? And it's like, oh, that was painless, and so, yeah, I think we do have folks who come in having gone through the experience of not having a plan and having to sort of clean up someone's estate with or without an attorney, and then they go, oh, time for us to do our plan so that our kids don't have to go through this.
Well, if our listeners wanted to learn more, you folks are having seminars, right, about
Yeah,
about
so
this.
we do, estate planning group, we do offer free seminars on what we call the nuts and bolts of estate planning. We have been doing them just this year during the weekdays, but we've started to do Saturday seminars, and we're also moving out to the neighbor islands. I'm doing one tomorrow on Maui, but there is one at the end of the month on August 24th. That will be at our office building, the Ala Moana Pacific Center, and that's at 9:30 in the morning. And then there's one on August 30th in Hilo. So if folks wanted to get information about those seminars or to sign up, then they just call our office, 808-942-8778. And if they want, any more information about estate planning or to set up a meeting or anything, yeah, that's the best way to do it, is just to call our office.
Okay, great. Well, thank you so much, Stacy, for all that information. Again, we have Stacy Takekawa with an estate planning attorney with the Estate Planning Group. Thanks again for joining us.
Thank you so much, Andrew.
Don't go away. We'll be right back with our real estate tip. Sorry, Chaz.
Was that too long?
Well, I think our conversation went a little bit long. Let me see how he's able to cut it.
And I didn't do my stories, but that's okay.
Yeah. But I mean, we had a lot to talk about, and I think going into detail about the certain was good. Wow, see, this goes by so quick.
It does go by fast. I know that from last time. Is there a trivia question? Is there a trivia question? Oh yeah, there it is.
What is that?
Your trivia question.
Yeah. We're just gonna close up. And now we have our KupunaWiki Classic Trivia, brought to you by Cheney Brooks Trust Advisors. Jurassic Park made its debut in 1993, featuring Oahu's gorgeous lush valleys and rugged mountains. What was the name of that specific location? For a chance to win a Longest Gift Card, be the first person to call us with the correct answer at 808-792-5188. And again, KupunaWiki is live, and our next seminar will be on Saturday, August 10th, from 10 to 11 at Ilima at Ehano. We will have Debbie Kim Morikawa with Gym Guys, and she will be talking about Fit for Life. To reserve a seat, call us at 808-792-5188. Again, we'd like to thank this frequent sponsor, the Hawaii Retirement Center, for providing local seniors independent and assisted living opportunities within their all-inclusive community. To schedule a tour, contact 395-9599. Thank you again for joining us today on the KupunaWiki radio show, Hawaii Senior Resource. We strive to make our seniors informed and supported every step of the way. Again, I'm Andrew, and we'll see you back next time on the KupunaWiki radio show. Ooh! Looking at Chad to see if
we have to do it again and less.
Well, I think we're okay. He's gonna just probably cut. What we do is probably just cut one of the ads.
Oh, really?
Well, we've been playing them for for free lately. So we've been giving them extra ads. So.
Got it.
I think we're good.
Okay.
Yeah. Okay. Well, thank you.
Diana.
Huh?